participating in any matter coming before this commission with respect to which there is a conflict of interest or appearance of conflict. Does anybody know of any conflict with regards to the proposed agenda that we have at this point in time? If so, let us know. I don't know where that came from.
The live stream played for a moment and it's delayed. Sorry.
So can we cut it off? Or are we going to hear us?
The live stream on ours, so you won't hear the echo.
So we're not going to get an echo all
I
day.
thought you had a double voice.
Great imitation.
All right. Okay, so are there any conflicts? All right. All right. So moving right along into the commission business. Whitney, do you want to tell us about the 2022 meeting calendar? That had some adjustments this morning. So
That did have some adjustments this
Yeah,
morning, and
thank
I
you.
apologize. I sent an email to you, to the folks who are online this morning with an amended 2022 proposed calendar. And each of you in the packets that's laying in front of you would have it as the very last page. The proposed dates for 2022 now would be January 28th, 2022, April 8th, July 15th, and October 28th.
I'm gonna send that out to you know, all of us.
it should have been sent out.
It was sent out to all of you, and those of you who are present have it in paper. So this is open for you to discuss, given the conflict dates that may be listed at the bottom, and then adopt as our calendar for 2022.
See if I can find that.
It's the stapled packet that
This new one,
Okay, so the new one.
right there.
Give me the last
Oh,
one.
okay.
Coming back.
All right, thank you. Sorry.
There.
Let's see.
So you have the proposed commission meeting date schedules at this point in time, January 28th, 2022, April 8th, July 15th, and August or October 28th. Is any this on the very back page?
Okay, no, I was just looking for another packet.
Does anybody have any discussion with regards to the proposed dates of the commission? I think those commission meetings are to be announced where they're going to be held. I think they're going to try to move them around a little bit so they're a little more accessible to some of the folks in the West. But I'll leave that to folks with a higher pay grade than I have. So do we have a motion to adopt those particular dates at this point in time?
So moved.
All right, Brian's moved, second from Brian. Any discussion? All right, all in favor of adopting those proposed commission dates, say aye.
Aye.
All opposed? Okay. I do want to go back to one thing with the State Government Ethics Act. Whitney did a really good job of outlining what the State Government Ethics Act and lobbying laws are. They're in your packet. I'd ask you to take a look and review those. Those are important. Especially in light of the fact that for the new commissioners who will be coming on, you've got a education requirement every 2 years for the State Ethics Act compliance, and you also have to file your statement of economic interest each year for being on this commission. That is a requirement under statute. So take a look at this packet that Whitney did. It kind of outlines what your obligations are and your duties as a individual on this commission. So you want to say anything else about that? I know that Whitney will probably be sending out a reminder.
I
Does all
do,
the
I make a great effort to annoy the heck out of you through the spring about your SEI. The statutes in the memo have been updated. I updated them just a couple of weeks ago, so.
And the real issue is that the state of North Carolina will fine you $250 for not complying with that, as one of our members has experienced in the past. And ultimately you could be kicked off of the commission. So anyway, all right. So I wanted to go back since Whitney had included that in the packet. I think that was, thank you for doing that because that's a big help. Next, part of the commission business is the report of the appointments committee. I'm going to recognize Dorothy to handle that. We have a couple, you can just explain how many people we have coming on.
Okay,
Is that, you didn't know you
I
were
do.
supposed to do that?
I do.
Okay, okay.
But when you said a couple of people coming on and we're talking about.
Well, before long, you're going to have to replace
We
me.
know.
There's no replacing you.
We know. All right, good afternoon, everyone. The report of, the appointments committee had the duty to discuss some candidates or some persons that had been tendered to us to fill the seat currently held by Channing Jones. That particular seat is a specific seat that should be held by a person of Native American, a Native American person. And so we had two phenomenal candidates or persons that we spoke with. We had some extensive conversations with the two of them. And you all, the commissioners, you have their resumes and information in your packet. And so the appointments committee met and we unanimously voted and recommend Karen S. Franco, who, as you commissioners, you have, like I said, you have her information in your packet. We believe that she would be a great addition to the commission. We believe that the experience that she already has in the community and the work experience that she has will be very fruitful and to us here on the commission. And so that is our recommendation is for us to appoint Ms. Karen S. Franco to the commission.
That is a recommendation coming from a committee and does not need a second. I just want to open it up for any discussions in regards to that nomination suggested. Anybody? I would call it to a vote among the commissioners, all in favor of nominating this individual for Channing Jones' spot on the commission, say aye.
Aye.
All
Aye.
opposed? That passes. The next matter I'll take up is the chair and the vice chair elections. As many of you know, I will be rotating not only out of the chairman position, but also will be rotating off of the commission as of 5 o'clock today. And so we usually have a chair who serves for 2 years. Of course, my 2 years is up as of today. We also need to also elect a vice chair. The recommendation of the appointments committee is that Dorothy Harrison Mitchell be appointed as the chair of this commission and Art Wheeler be appointed as vice chair. That is a recommendation from the committee. It doesn't need a second. So is there any discussion with regards to that? All right. All in favor, say aye.
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 All right. Congratulations. I'm going to defer the remarks from the outgoing chair and just move along with the agenda at this point in time. And I'll ask Mary to go ahead and give us a report on the director's perspective.
All right, I'll be brief because we have a busy agenda today. Wanted to update you on a few matters that we have discussed before. First, the status of the Alamance County Early Representation Project. As you all know, we entered into contracts, IDS entered into contracts in the summer of 2020 to provide counsel at first appearance in misdemeanor cases in Alamance County. IDS had agreed to do this to facilitate consent preliminary injunctive relief in a lawsuit against Alamance County and its senior resident and district court judges. In October 2020, after discussing the program with the commission, I told counsel for the judges at the Attorney General's office that we would continue to do this project through the expiration of the contracts, which was then scheduled for November of 2021, or through the end of the injunctive relief period, whichever came first. So two developments have occurred. First, we learned in August that the discovery period in that lawsuit was just beginning now. So there's no end in sight. Second, and I think probably most significant, is that in August, the General Assembly enacted a bill that was signed into law by the governor, and it provides for first appearances and misdemeanor cases, which is a really good development. That's one of the aims of the lawsuit. But this legislation explicitly provided that a first appearance is not a critical stage of the proceeding, which is crystal clear legislative intent that the state does not want to fund first appearance representation. And I do not believe that we have the authority to spend PAC money on this program, and have informed council for all the parties that we were going to have to end it at the end of November. I was fine with, honoring the earlier commitment we've made to the Department of Justice about that. And that's where it stands. I don't know, there may be an attempt to bring IDS into the lawsuit, and if we were a party and under that order, it would be a different situation, but under the, we don't have the funding to proceed. So that's that. Update on the contract defender program. As you know, we are moving forward with winding down the unit-based RFP contract system, and we're replacing it with what we're calling the MAC program, for Managed Assigned Counsel Contract Program. There's a memo about this in your materials. It's still a work in progress, but basically we're trying to transition to a system that's based on hourly payments. So it's transparent and evident to everybody doing the work. We're going to start meeting with the affected local bars for feedback over the next 3 months. We have our first meeting scheduled in Caswell County for November 5th. We're also moving forward with a request for proposal for billing and timekeeping software that could be used by the contracting attorney, something that's simple, something that's available on a mobile device, and something that'll help us get our data and information that we need. So AOC is going to issue that RFP. I believe next week is the time frame we have. We have to sign off on the final product, and we have a meeting scheduled for Monday on that.
Yeah, Mary,
Excuse me.
is there a preference? Do you guys have a preference for the software?
So, we're doing an RFP to see what the best fit is. We do, there is one program that we've looked at that we think would work well called Defender Data, but we're going to look at any bids and see what works and who's the cheapest.
I
Right.
understand.
Yeah. Okay, so my update, thank you, on the 8-year plan. This is still a work in progress. We've worked with the State Office of Strategic Partnerships, which is a subset of or a division of the Office of State Budget Management, to meet with potential research partners. And we've identified one possible partnership with a professor at UNC Charlotte, who might be able to provide some helpful analysis for us. But this project is very much taking shape, and because of funding constraints and timing, will probably be largely produced in-house by our able research department. We've included in your materials a copy of the strategic plan that we put together for OSBM for the 2020 and 2021 biennium. We provided it to the state budget office in the spring, and this was overlooked in the summer materials. It should have been provided to you at that time. This is not what I would call a comprehensive strategic plan for the agency, which will be developed to complement the 8-year plan, but it was a document required by OSBM. We developed it in collaboration with the state defenders and the office staff. And I'm pretty pleased with the end product, particularly the statement of values that we worked together to come up with that is now on the IDS website. In other long-term planning, I don't know if this is long-term planning or just an observation or something I want to bring to your attention, but I think you all know that, or most of you know that we're getting to places where we have critical shortages of roster attorneys available to take cases statewide. And we have public defender offices that their caseloads are just backbreaking and they can't absorb any more cases. So a couple of things that I want to call to your attention. One is in your supplemental materials yesterday is a report that the State Bar adopted, that the State Bar Issues Committee adopted at its last quarterly meeting. It's the Private Assigned Counsel Caseload and Compensation Study. And it was, I think, really well done. Darren was on the committee that worked on this project. State Bar staffer named Alex Lively put together a survey and worked with all the stakeholders to see what was needed. And the report is it's important, it's thorough, and it's pretty frank that a lot of lawyers have left the work, and that a significant number of lawyers who continue to do the work are concerned about their ability to provide effective assistance of counsel because of their caseloads and because they're working too many cases. So that's a concern. Darren and I met with Chief Justice Newby recently in Darren's capacity as the new president of the State Bar, and shared a copy of this report with him. And Judge Heath has asked me to meet with him and talk about it next week. And we're also going to talk about public defender caseload. So we're getting to a crisis point. Don't know what we're going to do about that. Many senior resident judges have asked us to develop public defender programs in their districts. That we've visited with a number of local bars who have asked us to do that as well because they're overloaded. But again, that's all going to take legislative authorization and approval. So long-term planning. Finally, on my notes here, I'm supposed to discuss the legislative session. It's still happening. I've already noted the first appearance legislation. We are optimistic that there is going to be a state budget as soon as next week. Keep getting good reports from people. Darren is skeptical, but Darren, you're a glass half full person, Darren. It's going to happen.
I went to a fundraiser last night where Speaker Moore was, and I think you're right, but I think it's going to be an override of a veto, and they think they have the Democratic support to override the veto, which is good.
I don't care how we get a budget.
And I told Speaker Moore that probably we didn't care how.
I'm glad you relayed that to Speaker Moore for us. Wow. Well,
I'm sorry?
Just that we get a budget. It's a hell of a way of running the
It's been
government.
3 years, right?
Yeah.
anyhow, I'm optimistic and Darren is optimistic that we're going to have a budget. And we're going to discuss today and ask you all to vote on a proposed new rate structure that would be contingent on getting this budget and on it having, on the budget having the funding that was allocated to us in the state house budget that we previously circulated to you. And we are also optimistic that that is the number that is in the conference report. And the reason we're doing this today is so we can hit the ground running the day after the budget happens instead of having you bring you all back together, because we would like to get those rates raised as soon as is possible. So with that, I'm going to, I think, turn it over to Elisa, who needs to do her presentation before we discuss rates. But no, Kate has a question.
Mary, can we go back to that very first issue that you talked about with the legislative on first appearances and I mean, obviously that is that legislation is deeply disturbing because we know how critical that stage is, the first appearance stage, and to not have counsel at that stage, we know as a defense organization that that is, simply wrong. And so my question though is, I know the money is an issue. However, we have this one litigation that is going on in Alamance County where we are, we have committed to doing it up to a point till November through contract. If we back out, or end it at the end of the contract, aren't we likely to be brought in as a party to the lawsuit by not providing that? And isn't that going to be far more expensive than just providing or finding a grant maybe to provide that?
Well, we suggested to the county that they provide grant funding, as is done in other counties. It's possible, but Kate, I don't think we have the authorization to spend PAC funds, just like we can't spend PAC funds on Class 3 misdemeanor representation. And people have threatened to sue about that. I just don't see how we have the authorization. I'm open to other viewpoints. Art.
I was going to ask a question about that too, so I'm glad you did. But Was there any rationale given by the legislature? Not that they have to give any rationale of why they, I mean, a lot of them are attorneys. I'm not an attorney and I realize how very important first appearance is.
Yeah.
Any rationale of why they decided not to do this?
I think it's a cost measure. I think it's a cost measure. Something else that they didn't include was a time frame for the first appearances, which there was a lot of advocacy for having them within 48 hours. But again, that's costly because it requires additional sessions of court in counties that don't have court very often. And I believe it's purely related to court. I believe in first appearance representation. I've been clear with every counsel to all these litigants that if I were a judge or if it was up to me personally, I would fund this representation, but it's not up to me. And
I understand
yeah,
that. I just wondered if there was a good rationale, and I'm not hearing a great rationale. I'm hearing cost.
it's cost. It's cost. I
Right, but
think.
the legislative action and what we do seems different. Is there not another source of funding besides the PAC funding that we could put towards this? Is that the only available?
So a number of years ago, Tom Maher did a pilot project in Haywood, Jackson County that he funded through lapsed salary. That was much less expensive. And right now we do not have the lapsed salary to provide ongoing lapsed salary out of the central office budget in Alamance County. So,
I mean, I think, this is an issue that so many advocacy organizations and community members across the state are working on and understand even the 3 days of pretrial detention and the impact and how important counsel is. I can't believe that there's not a grant out there, and I don't trust, honestly, is Alamance County really, they're already under the lawsuit. They're a party already.
right.
I mean, this would be something that I would think IDS could seek. And say, this is a pilot project. We're seeing if we have some data from what's been happening in the last year about the improvement in.
Well, we have asked for that data from the plaintiff's counsel because that was something I would like to pursue, but that has not been forthcoming.
But yeah, well,
Okay. I mean, we'll ask again, and if
right. I don't think it should stop us from seeking a grant. I mean, I think as the statewide defense organization, we have an obligation to say that we disagree with that legislation and we want to seek funding outside the PAC funds to continue to support representation for first appearances just in this one county until it becomes, once this lawsuit is settled, maybe it will be transformative. And that
I do believe it will be transformative, right? And if we were a party to the litigation, or if there's if this goes to the Fourth Circuit, and assuming Judge Osteen finds it's a critical stage of the proceeding, then we can spend PAC money on it, right? But I hear you.
we have an obligation to look beyond PAC money to do this. It's too important. This is such a critical part of indigent defense.
I just had something quick.
Yeah.
It seems like at the next judges conference, just to encourage judges, a lot of courts see the same people come in and out, and they can, on their own motion, appoint somebody in the courtroom and then hear if there's anything that they want to say on that person's, almost in a provisional, as if they were provisionally appointed at the first appearance, and that wouldn't take care of all of it, but would take care of a lot of it. And I think if the judges were made aware of that, and so they can, without, if they already know that they're indigent, they can just appoint them on their own motion.
I think the issue with that would be the same as the issue with the class 3 misdemeanors, is that we do see judges appointing people for situations where there's no legislative approval, right? And at least sometimes, right, we don't pay people. The other issue is some guardian ad litem cases, right? There's kind of a murky understanding of when IDS pays for a guardian ad litem. So I get it, right? And if I were a judge, I would want everybody to have this counsel, but I'm very constrained by. I believe the agency is constrained by the state budgetary rules and what the PAC fund is designated for. And, when we go to beg for more funding, to raise rates and to do everything we need to do, it's difficult to be, well, why are you voluntarily spending money that we told you not to spend? It's a balance. And we can certainly try to find some resources to seek grant funding.
So, is there any other discussion about that? I don't think we should do anything contrary to what the legislature is asking. is permitted us to do because I think it's important that we find it.
Darren, excuse me, could you speak up?
Sorry. I think it's important that we stay in our lane on this. I know that those issues are important for us to advocate for, but in this instance, I think we need to stay in our lane. And as we try to continue to get more and more money for not only the PAC, but also to the public defender system and get new public defender offices. I think that's critical at this point in time, and that we got public defender offices, that would solve a lot of that problem. So, okay. So I'm going to recognize Alicia at this point in time. You're going to go through the proposed possible budget that Mary is excited about.
And I'm gonna try to do it from here, if that's okay.
Should we dim the lights?
It's right there too.
Oh, okay, there we go.
So, in sort of an annual event, usually early in the fall, we allocate a lot of time on your agenda to review the spending in the prior year, primarily to be looking for trends that impact decisions to be made, not just as an academic exercise to, you know, how many DWIs did we pay and how does it compare to a couple years ago, but I try to think of things that are important for decisions you want to make. And for many years, when PAC spending was unpredictable and the unpredictability would create problems such as shortfalls, you know, trying to figure out what evidence or what information there was in the past couple of years that would help us get a handle on the current year or future years was.
Gotta give you this. I don't know if I can, okay. Two
Or
things.
or you can stand behind the podium.
Okay, can people, this is okay. You know, was really important to do some detailed stuff. And of course, we're not in a position to do that right now because neither 2020 or 2021 were representative of prior years or future years. And so this jumps around a little bit differently in terms of the issues that I think are both important sort of background context for what the really important discussion is, which is what can we do about hourly rates given the expectations of several funding streams and several options that we'll hopefully know more about within a week or two. So anyway, so it's just a little different, just not quite as detailed on some of the specifics. So just for context, just to sort of talk about the different ways that we deliver indigent defense, some just basic measures of how that spending's divided up, some sort of key measures about both our statewide specialized defender programs and our local public defender programs, a couple of county snapshots just to try to show how it all comes together differently in every county, and then some highlights of the PAC spending this past year that seem important for projecting the costs in the future. And then the more important discussion in your supplemental materials was the memo based on a budget committee meeting we had earlier in the month, and some additional analysis we did after that to give some specific proposals and specific projections over the next few years that would allow rate increases to come into effect sooner rather than later. So this is just sort of the basic, are looking at all our payments to private assigned counsel, what we actually spent, and this is both attorneys and support services, you know, a little bit more than half of our budget, and then 38% that's to our local public defender programs, and the smaller amounts to the statewide programs and IDS administration. And that IDS administration percentage, which is much what I challenge any other state agency to measure that low, has hovered just under 2% for pretty much forever. Just a little bit notes on that, because I think it's important to recognize, you know, over $1 million of our administrative spending is really our financial services offices that are paying all the attorneys in the field. It's not really that the PAC wouldn't be paid if we didn't have that. And then we also have our regional defenders and contracts administration, forensic resource council. So some of what we call administration is really support to the field, our research division, 3 IT positions and others. And that, but even though I like to brag on our low administrative percentage, that's in part because AOC has always, from the beginning, when we were created, provided the more general support that would be very inefficient for us to do ourselves, which is the Human Resources Division, General Services and Purchasing, and their IT divisions. And then just another way to look at the costs, case related, which is everything we're paying to private attorneys or experts who are helping private attorneys, and the case related costs in our defender programs, which is if they're paying for an expert or investigator transcripts and things of that sort, is over half our budget. And then most of the rest of it is our personnel in our public defender programs. And operating costs are very small. That's basically in large part because the counties provide our office space and basic furnishings in the local programs. And so we're basically talking training, travel, supplies, things of that sort. Looking a little bit differently, but based on the volume of work done by these different categories. And these numbers aren't completely comparable. I like to say they're oranges and tangerines, because when we count cases for private assigned counsel, we're looking at the number of payments we made. And we have better measures when we're looking at our contract, what our contractors report or what our public defenders report. But of course, the overwhelming volume being per our assigned counsel. And then the other, just gives sort of a sense of the scale of how much is done by our other programs. Specialized defender programs, that number is weighted heavily towards the special counsel office, which does very high volume civil involuntary commitment proceedings at the state institutions and Wake County areas. It's a funny number. This looks at that breakdown at some key case types. So, for low-level felony, where there's the high volume by fee application, but also a significant amount by our local public defender programs. I think that's probably the area where we see that in district court criminal is where our local public defender programs are neck and neck with private assigned counsel in terms of the volume of work being done. And then there are case types where almost all of it is done by individual attorneys appointed to individual clients, such in child welfare cases is another good example. Involuntary commitment? Yeah, I know we call it voluntary if it's juvenile, but we lump all those numbers together. And then just some basic measures on our specialized defender, or all our public defender programs, how many attorneys we're talking about, the costs, which is mostly personnel costs, and the dispositions they report. And again, these aren't completely comparable, but like our juvenile, in most of our specialized defender programs do things other than direct representation. Like our juvenile defender program does tons of stuff in the field, but 2 of the staff attorneys are doing dispositions in their home counties, and it's not an insignificant number over time. In Office of Parent Representation, those are appeals of child welfare cases that they do out of that office. And these numbers, like everybody else's numbers, are lower in 21, but not as much lower as, say, looking at PAC spending. Rather than give lots of details about the public defender offices, I just wanted to focus on a few key things. The total dispositions reported by our public defender offices in the online system we provide them has trended down for several years. Not something we have ever completely explained. Some of it has to do with something we've seen system-wide in a drop in the volume of lower level cases, which I think were high volume within the public defender programs. And some of that's the change in entitlement to counsel for class 3 misdemeanors, even though it was a number of years ago, seems to have worked its way through the system slower. So we were seeing downward trends. And of course, what we're seeing in 20 and 21 is COVID related. It wasn't even across all our counties, just because the response to the pandemic wasn't even across all our counties. But in some of our programs, there was dramatic drops, particularly in Mecklenburg is one of the ones where we saw a very dramatic drop, which might have been multiple factors, not just COVID. And then in some places, the dispositions in 21 weren't that different than prior years. The other key thing we're looking at is although it's hard to get a handle on caseloads and pending cases when we're looking at so many different programs, we do have a report we were able to run that counted pending clients in the system that the public defender's offices use. And we had done that back in February for a report for the legislature, and then we did it again in September. It didn't change very much. That's hard to look at what does that number mean, but when we look at how many pending clients there were as a percentage of how many dispositions that program usually did in a given year, in some places it's scary because I mean, the cases are still coming in at the same pace. So if you have pending clients, that's about as much as you usually do in a given year, then you're almost doubled your caseload. And again, it's not even across all our counties, but there's a large number of them where it's sort of, that measure is more than 70%. And I was just remind that we have a lot of other resources in our public defender programs, and that's been growing thanks to the advocacy of our chief public defenders. You know, we've had an assistant public defender in Durham County for many years handling first appearances, large grants from Mecklenburg County, both for positions, including 2 social workers, but also they do a salary supplement to all the attorneys. It's controversial, but it's important. In Charlotte and Buncombe County, it seems like every time I turn around, we have a new Buncombe County contract for something else. And then the most recent one, which I think people are feeling really good about, is Cumberland County for the first time is funding an assistant public defender. I believe they've funded an assistant district attorney for years, and we finally got that parity. And some of the key issues, I know we've talked in lots of other meetings about the workload study. We haven't had the ability to do anything to address any of that. For the first time in the past 6 months, and of course we hear this story across all kinds of sectors, our public defenders' offices are reporting trouble hiring. We never heard that. We never ran vacancies. You know, if a vacancy showed up on a report, it was just because the person hadn't started yet. And so that's an unusual situation. And then the backlog that we were talking about. And then I think we hear as much from our chiefs in terms of as much about difficulty hiring as difficulty finding private attorneys to take the cases they can't do either because of conflicts or because of caseloads. And I know I was frustrated by this. We had a couple of proposed reorganizations of public defender programs that were neither expensive nor controversial, but important in those areas. And we weren't able to get any traction on getting legislative approval for those. I have these.
I'm starting to think it might be pay, and yes, the job market has gotten better for young lawyers, and I think the DA's office pay a little better, legal aid pays a little better. So I think it's, yeah. Yeah. And it's actually not, yeah.
I teach it too.
Yeah.
And that's a subset of what they do. I mean, these are the public defense for prosecution.
Right.
I just wondered why we're not finding it.
Yeah.
People don't do it for the money to start with.
But you have to have enough, you have to be able to pay your loans and eat. Yeah, and your rent. And it's not just the assistant public defenders, these new social work positions, the chiefs are having a very difficult time finding people to fill those as well. So.
So I just did 3 county examples because, in the staff level, when we talk about changes, every county is a little different in terms of its combination of who's providing indigent defense. So I use Forsyth County example because we've been talking a lot about Forsyth County. And so we have a sort of a fairly large public defender's office. And again, that cost is mostly the personnel costs. That's an office where the dispositions really plummeted in 21 compared to prior years. That's a county where I guess things really slammed shut at the start of the pandemic. We've, for a long time, had 2 attorneys who do juvenile defense work there under contract. So the public defender's office doesn't do it routinely, but we have experienced contractors who have been doing that under the supervision of the Office of Juvenile Defender. We also have one very large civil contract where someone's done very high volume of competency and civil commitments there. So again, that's something that we're not having to do by fee application or through the public defender's office. And then the smaller costs related to the payments to private assigned counsel, and I've just broken that up for just looking at the attorney's costs by capital and non-capital. So you can see, $4.4 million spent in that county, most of it through the public defender's office. In normal years, the majority of the casework by the public defender's office. When we're measuring dispositions rather than caseload, that doesn't show up for 21, but that's sort of the volume. Wake County, I'm sorry.
You said the civil contract is one attorney.
Yeah, he saves us a lot of money. It always, I don't know, maybe I shouldn't have used this on the slide because it jumps out, but the number of cases he handles in the local facilities is in the hours that's put into that. So it's most of his practice.
Much more, his salary is much more than the public spending. Or his public spending in the
Yes, and but before his overhead or anything else, but yes, yeah. It's one where we've looked at the cost effectiveness of it. And just a couple of our offices handle involuntary commitments, just. He does competency proceedings too, I believe. Yes.
there are usually a couple of people helping.
Okay.
Has that changed?
He's the only contractor we have, but yeah, I'm sorry. Maybe I shouldn't ever put something in a slide that's going to provoke conversation that I'm not an expert on. But
There are two additional attorneys to assist him. So my guess is he pays them to do some assistance because they're three hospitals.
Yeah.
So my guess is that's just not one person doing all the work. It has to be a contract person.
it's with the firm. Yeah. It's a firm.
For a long term, whoever was doing it, Fred, from the beginning. Oh, yeah. He's handled a whole bunch of stuff. Like they don't know, and all you know didn't watch it was Fred, and he did a great job. So
Yeah.
about your county,
I wanted to point out that even in cases where maybe it would make economic sense to add a position in a PD's office, we are not allowed that flexibility. We need specific legislative authorization to create a position, so.
Yeah, and that's one case type where we've learned it's very hard for someone with a regular private practice to take on that case type. So Wake County is a bigger county, and so we're spending $8 million on indigent defense in Wake County, a little bit more than half of that with the public defender's office, and then that's where we have larger volume adult criminal contracts. So that in 2019, our last normal year, the adult criminal contract dispositions were almost as much as the public defender's office. And then just for contrast, using a smaller county, Catawba County, where we have no state employees, no public defender's offices. We do have a couple of parent rep contracts, both juvenile defense and parent representation. We've seen increasing use of contracts and anticipate even further increase use of contracts. And this sort of gives you the scale of that. And not that there's really a consistent story to say about this, but it seemed just kind of helpful. If we're looking at three counties, what do we know about these counties? Obviously, Wake County is really large. In Wake County, if you just take all that we're spending and divide it by the population, it's about $7 per person. It's the same amount in Catawba County with a much smaller county but higher levels of measured poverty. And then you have Forsyth County in between, where the cost per person is much higher. Probably, I don't know how to describe it. It's just a little bit of the story that every county is different when we look at all these things. And IDS was created to figure out the best way to deliver indigent defense statewide. And then when the rubber hits the road in every county, it's a little different. So that's sort of the overview of the system, just things that I thought were good background, and then sort of leading towards the discussion about rates, just a few highlights of PAC spending last year. Last year, our spending I also have to remember, yeah, I'm talking about spending here, on contracts was a significant percentage, a little higher than normal because contractors got paid more regularly than people who couldn't submit fee applications after a certain point. But it's still been a significant portion for a good while. When we talk about PAC spending, we're talking about also payments to experts and investigators, mitigators, transcripts, interpreters. And that's, those are significant dollar amounts. We don't tend to do as much analysis of those, but we're starting to look more at those and what are there better ways to organize the delivery of those services and encourage them more universally. The spending on experts and investigators is not uniform across the state. And this looks at just looking at our, most of what we've been talking about is spending. The best way for us to analyze trends is to look at cases that are disposed of in a given year, because there's the deadline, the 1 year that people have to submit fee applications. If we're looking at spending in a given year, it's not necessarily representative of what's happening in that year. Unfortunately, we don't have current year's dispositions until years later, and you don't want to use 2020 for anything. And so to get a picture, I'm really going back to 2019. In fact, I used 2019 figures to calculate the cost of rate increases, because that's the only year for which we have, a normal full year's worth of activity. And so this shows the bulk of our work being district court, criminal, and civil in terms of volume. And that's why those providers had to take the deepest cut in 2011 when we had a budget crisis. And that's why it's been so expensive to try to address that, just because by virtue of the volume. This ranks things sort of a different way, looking at spending on fee applications, excluding contracts. Where is the greatest volume? This I sort of look at as sort of the pain point, the people who every time they submit a fee application, they say, I did this case and this is all I'm getting. Low-level felonies, adult low-level felonies being the single hardest, and following closely by child welfare cases, and then district court and capital being sort of the next large categories. Actually, I'm not going to talk about that. Okay. The other thing that I think was sort of important to look at in terms of discussion about the rate increases is if you look at average payments per case, and we didn't do this in every county. I worked with our research division on this, looking at the counties where most of the payments are by fee application. So there's not big public defender's offices handling most of the work, or the adult criminal contracts. And so what have been the trends over time in the average payment per case, just dividing the total spent in those broad categories by the number of payments. And so that you can see relatively stable until 2019. The increase in district court spending in 2021, despite the pandemic, is those targeted efforts we were able to do, primarily district court low-level felonies, when we made it so that a low-level felony in district court was the same as in superior court. And then probably the increase in 2020 for superior court spending is based on the increase. Well, I don't know. Actually, I was going to say high-level felonies, but that's probably not it. And then juvenile, of course, we're starting to see a little bit of raise the age, but because of the pandemic coinciding with the implementation of raise the age, we don't really have a good analysis of any of that yet. And then this, I think, is important to keep in mind in terms of when this is average cost per case by different categories, more refined, so that if you're looking at high-level felonies in superior court, using 2020 as a representative year, what is someone getting under $2,000? If you look at a low-level felony superior court, under $500, low-level felony in district court, $300, and that misdemeanor, the average cost for misdemeanor, and I excluded the A1s because we had just adjusted the rate there, still hovering under $200. So that's our high volume work, and where I think we're hearing the most. Well, we're hearing it from everything, but just that's the biggest piece of it. In terms of trends, because we're at a point where it's hard to sort of look at trends. Again, I worked with our research disposition because it's better to look at disposition year when we're looking at long-term trends. You can see how there's lots of variability from month to month. Sometimes when we would have commission meetings, I say, we're spending 4% more than we had this year. A lot of that tough stuff tends to smooth over time. You see the big drop in district court, which had to do with restrictions and entitlement to counsel and probably underlying changes in the field in both law enforcement and prosecutorial behavior that we were certainly hearing about, drops in charges for low-level cases, even separate from the class 3 misdemeanor case. And then, of course, you see the dramatic drop-off with the pandemic. And the other thing this seems to show is a slight increase in the share of our work that's probably Superior Court, which I don't think surprises any of us. That's consistent with the drop in the volume of lower level cases. So looking ahead, this year has looked like 2019 in terms of our total spending through today. That's not exactly a deeply analytical, but in the absence of other ways to figure out what's going to happen this year, and because this is an important point for us to be projecting the rest of this year and what that means for future years, the best answer I have is it will look like 2019. So if our PAC spending is the same as in 2019, that's actually a slightly lower level of court activity because our spending today reflects the rate increases that you adopted as of last March that wouldn't have been reflected in future years. So that's the sort of the baseline projective. In looking at our different sources of resources to cover the PAC, which are our appropriations, our receipts, the funds we were able to carry forward from last year for the first time, and funds we moved from the public defender program at the end of the year from lapsed salary, I would expect this to be a more or less break-even year without having to use all the lapsed salary we normally would from the public defender's office. That also gives us a cushion if spending is higher this year than we otherwise thought it would be. What we've learned is if we have PAC money that's appropriated in the PAC, receipts that come into the PAC that we don't spend, we get to carry them forward for the next year. But if we have salary funds that are unspent in our other programs, those revert at the end of the year. So if we say it's going to be a quiet year, we have enough money to do what we're doing right now, probably won't have a lot to carry forward, but we'll leave some funds unspent in our public defender programs. To what extent is that a risky assumption? Our set-off debt receipts that come in all at once in March and April, that's always a hard one to project. It's been fairly stable, but there's no way to model whether that would change. The one time we had a surprise change in that was when DOR changed the withholding tables, so fewer people got tax refunds. I'm not aware that that's happening this year, but it takes something like that to move that number very much. And then the other thing is we've been hearing for a long time that the court system was going to add resources to speed up to deal with the backlogs. We haven't seen that in any kind of wholesale fashion, and it's we're getting almost towards mid-year. But if that came out gangbusters in December, January, February, and night court and emergency judges and everything else, and the volume of our work suddenly picked up and we were taking care of some of those backlogs and they were picking up all those people who haven't come back to court, that would also affect our spending. I don't think we're going to see that in a big way, but we're not sure. So the budget committee met earlier in the month and looked at different options. In the mood we got coming out of that meeting was, it's a crisis, that having to do something about rates was a now, not later. That it would be very uncomfortable to leave funds unspent, but that Chris Mooma, who's no longer on this commission, but on the budget committee, had a good reminder that most people on this commission don't remember when we had significant shortfalls. And that that's a history that we felt was important to share that was in the materials that we sent out in advance. So that there's the risk of shortfalls for making decisions. If you make decisions about raising rates, that's a recurring cost. Small shortfalls can snowball over time because it means that the beginning of the new year, you're spending the stuff you weren't able to do the prior year. But on the other hand, if you don't go bold, particularly a year like this, we could be leaving funds unspent on the table that could have been used in the PAC. So based on that, we put together a proposal that's roughly $10 million. There's other uncertainties. One big uncertainty is we've been working for a couple of years to get federal reimbursement funds for child welfare cases, where we can get as much as 24% of some of our spending reimbursed by a federal program that's uncapped, that's been almost impossible to get in operation. But we're supposed to be getting funds starting very soon. Now, it's hard to spend that. This has been such a tortured process. It's hard to commit spending those funds until they come in, just because there always seems to be something else that gets in the way with us getting these funds. But when they do come in, they could be a significant piece of funds. In our memorandum of agreement with the Department of Health and Human Services for the use of the funds includes using them for rate increases. Some of the funds are going to be used for adding social workers to those cases, but over time, there will be funds available towards our towards rate increases. The other sort of piece of the puzzle, which is sort of complicated to forecast, is that we're also hoping that the budget that we hope we will see next week opens a new public defender office in Cleveland, Lincoln County. And when we open a new public defender office, we take money out of the PAC fund to create the positions. It might come with a small appropriation to make up the difference in estimated costs between a public defender program and PAC at current rates, but that we are going to be pulling money out of the PAC fund to create the public defender positions. So how fast we create those positions and how fast that office moves work from the PAC to the public defender salary program is also a factor that's hard to forecast. So the proposal that was in the supplemental material, and I have a screen at the end, but the highlights are it would raise the floor to $65. Those rates that have stayed at $55 would all go to $65. It would also change the structure of how we pay capital related cases so that there would be a single rate. And that single rate would also apply to non-capital cases, LWOP cases, violent, habitual offenders, some other sort of, they're small categories. But basically, if you're facing life without parole or the death penalty, it's at that one flat rate. And Rob Sharp, our capital defender, has advocated for that change for a long time. It also provides, your last commission meeting, you had a presentation from an investigator mitigator. It also would provide a modest increase for investigators and mitigators. We'd have to work out the investigators, I guess, with the Conference of DAs, but that's the first time we've addressed that kind of issue in these proposals. And high-level felony would increase again to 85, so that would be 2 increases in a short period of time. And we also tried to shrink the gap for non-capital appeals between the high-level felony cases and the other cases. I'm going to go ahead to the screen with the proposal. So this sort of shows the chunks of costs that are part of this proposal that's roughly 10 million. Going to $65 in district court and superior court, of course, is the single biggest chunk. Addressing low-level felonies in both those courts is a smaller one. The other proposals dealing with the specific capital rates or the non-capital appeals don't have the same or nowhere near the same magnitude. But this is what it would look like in terms of our rate structure. It would be a complicated rate structure. I wish it weren't so. But this is the proposal that's sort of coming out of the budget committee discussion. And again, just the uncertainties. So what we hope is in the budget is 5 million new appropriation recurring and new fees that would bring in 1.8 million on an annualized basis. So how do we go from saying we're going to have $6.8 million in recurring new money, let's spend 10. And that's been sort of the topic of discussion in the office, I think, for most of the last week and a half. Why am I saying spend 10 million if we're only getting 6.8? Part of that is, in addition to the carry forward funds from last year, and the fact that we could, if we work things right, have additional carry forward funds to next year, there's a $4.7 million reserve that you directed us to put funds aside last year related to potential litigation involving the set-off debt program. And we hope the budget also has, and are as certain of this being in the budget as almost anything, is safe harbor related to that issue, which means there's a 4.7 million one-time pot of money that you wouldn't want to use to increase rates by that amount, but could be spread over several years in a prudent way to allow the rate increase to be more than just the new money. So that's the scenario that we were looking at, is spreading the non-recurring money over time, taking advantage of the new money. If you made plans today to raise rates, it would probably be effective January 1st. If we do $10 million in rate increases, it's only going to cost $4.5 million this year, because it's always slow to implement. The appropriation we get presumably would be the full amount. And so that's what makes it more likely there would be carryover funds at the end of this year to help cover the greater cost. So I didn't put in a slide or in a handout the complicated pieces of money coming in and out and different things that lead to this. Yes, with $5.8 million, we can spend almost $10 million. And I don't want to pretend it's not a risk. I mean, the biggest risk is if something unforeseen happens. The 4E money is risky. You know, like I felt that the estimated impact of the new fees that are in the rumored House budget were good numbers, that those were levels that I would expect those to bring in. Anyway, so there's some risk to it. In the supplemental material, and I didn't do a slide, I sort of said for the different, unless I need to switch that, for the different, does everybody have the memo that went out in the supplemental? So in terms of, none of these proposals would not eventually lead to a shortfall. So the question is, at what point might there be a shortfall? I can't hold it.
Page 4 of her memo has the shortfall scenarios.
So the two big pieces we looked at is what would be a no risk proposal? And that would be to raise rates $8 million, which would make it difficult to go to 65 in district court. And that would leave money that would have no significant risk of a shortfall in any of the horizons that we would be looking at. But then again, would again make that district court piece very difficult. The go large is the 10 million. And I've laid out scenarios both with the federal 4E funds, which I do think are going to happen, and they wouldn't be expected till 2023 under this scenario and without the 4E funds. And I think it's probably prudent to think in terms of saying, if we get the 4E funds, you can do this. If we don't get the 4E funds, we can't do that extra $5 in district court. And the 9 million, which we'd have to sort of craft a little bit how to, where to cut to get that down, brings a risk of shortfall relatively soon without the 4E funds, but if with the 4E funds, it would not be till 2028 under these scenarios. So it's a lot of dimensions to look at. I'm trying to think if there's a way, maybe at this point, it'd be good to take some questions rather than try to lay out more information.
Are there any questions?
So the question was, can we afford not to do that?
Can we afford not to go on the rate increases? I mean, I've been on the commission for X number of years now, and we've always talked about how do we get the rates to a basic level that we can bring in attorneys to do the work. I mean, I don't know a commission meeting we don't talk about that, okay? And so my question, and I understand what Chris said at the budget meeting. Chris and I have had discussions about this on a number of occasions, but can we afford as a commission not to move forward with the higher rate structures? I mean, I know we can do it, but we aren't facing the critical stage of having to do that right now. So can we afford not to take our best, I guess, crapshoot, the lack of a better way of saying it, to raise the rates to where we think we can take them with moderate risk? There's
Well-
always a risk in a budget.
I think my recollection of the budget committee was that any motion that we were going to make is contingent on the passage of the budget.
Correct.
So the question is, first of all, this is contingent on the passage of the budget. If the budget doesn't pass, then this conversation is moot.
Right.
And the motion that I recall coming out of the budget committee is that any vote we make is essentially to give Mary the authorization to enact this plan at that time. Is that correct?
Contingent on the passage of a budget with 5 million recurring, 1.8 annualized new court fees.
So for the other commissioners that weren't, and the other folks here, my concern was that, first of all, we should not leave any money on the table. Because if the PAC and the others know that there's some money left over after some of the emails that Mary and I have received over the course of the last couple of months, that's not a good place. So it's how big of a gambler are you? Are you somebody that will go to Harrah's and not have but $1,000 in your bank account and you bet 10, or are you going to be the guy that goes and stops at 1,000?
Or middle ground.
And some of the things that we ought to think about is if we go with the 10 million and we get the budget and we go with the 10 million and we get the 4E funds, and we do have this shortfall at some point in time that may trigger the legislature to give us a boost at that point in time, because I think we have established a history of being good stewards of the money that we've been receiving. And maybe we've built some cred with them that we are not. There was a time, I think, we can all agree, when money was not being used efficiently sometimes. And so, especially pre-Rob Sharp. And so I think that maybe hopefully we've gained some credibility with the legislature. And I'll just start. I just want everybody to know what a good ambassador you have, the legislature, with Mary going over there. Because I've watched that. The legislators respond to her. And so I'm in favor with us doing the 10 million. I think we need to, giving, I have a private investigator that does a lot of work for me, and it kills me that he makes so little money. And I think if we could give them even a little bit of money, and I think, Rob, I want to know, what do you think that's going to do with your capital folks to get $10 more an hour? I believe it will
improve the quality of representation. I believe it improves their ability to keep doing the work and allows them to possibly reach out and get additional resources like paralegals and secretaries.
Rob, you're going to have to repeat yourself because.
Yeah, come on down.
and-
You want to give him the mic, Lisa?
And then when they hand me the mic, I just say nothing. I don't know. Thank you so much. I appreciate the question. Question was, how will $10 affect positively, we presume, current counsel who do these capital cases? It's going to allow some of them to just simply stay in the fight and do the work longer. I have, within the past 2 weeks, we reinstituted something we haven't done in a while, which is because I didn't want to know the answer to this last year, which was, okay, are you ready, willing, and able to continue to do these cases? I didn't ask that last year because I didn't want to know the answer to that last year. And so I asked that this year, where we have the lowest number of people doing this work than at any point in the history of the organization. It's going to allow them to get paralegals. It's going to, as I say, allow them, some of them to stay in the fight. You know, I almost, and again, you talk about good leadership. I almost, but did not share the exact email with the commission. But I will say it said something about walking over dollars to pick up dimes. And it was a really, it's an inaccurate assessment of how the majority of the folks that do this work feel about this work. But there is this point, you know, I mean, and it's some of it's anecdotal, but you know, I've got student loans. I've done indigent defense my whole life. I've got student loans now. I've made a number of terrible decisions. Back to your gambling thing. No, I'm kidding. But you know, we need it. Like we need it. Like I'm right there. And I looked over the October of last year. I looked over the minutes last year, and same exact point. You know, we say this, and we say this, and I don't know who to put on the cases now. I'm not willing to send up the flare gun just yet, but I do think that we are at a really difficult moment. And I love that we've got a former deputy capital defender on the commission, just because I can say things to her like, we got 354 attorneys. We have 2,200 pending cases, up from 1,800 last year. We're in trouble. I think this, you know, this certainly is not going to hurt. And I don't think it's wrong to have a ceiling, to have a place that you can start to bring people up and say, you can earn this money doing indigent defense after you accumulate experience and things like that. I appreciate the opportunity to be heard on it.
I think the $100 also has a little bit of a reverse. I mean, if you know anything about marketing, you market something for $9.99 and they think they're getting a bargain. You put it at $10 and they think they're being ripped off. This has the reverse. It's $90 now. When they see it's a triple digit, even though it's $10, just $10 more, I think it's going to have some positive effect on finally they're recognizing something.
Yes, and I know this commission has long wanted to, and I hear the struggle year in and year out, because there's nobody arguing that the folks doing the work aren't underpaid at practically every level. There's no one, I've never had a commissioner stand up and say, well, it's those, you know, darn folks doing district court. They're the ones that are, the whole time I've been doing the work, I just haven't seen that. And so, I certainly can agree with that. And I just appreciate the potential risk, but I'm telling you, we're there. Like, we're there, is my opinion.
What about the potentially capital? I don't need that, do I? The potentially capital rate going from 80 to 100.
I have a couple.
Critical?
I have a couple of views on this. One view is, this is the only pay rate that I know of where the state directly decides what that rate's going to be by their actions or inactions. And that's a really bizarre thing, particularly given the fact that we can go, they can decline to hold a Rule 24 hearing, which simply means declare a case capital or not capital. And as you may imagine, if you're a capital defense attorney, you don't beg for that hearing typically. So you will let them delay that thing for years and years. And then they'll come up and say, well, we're going to go ahead and declare it capital anyway. So now you've been at the lowest rate we got for this significant period of time. Now we need 2 attorneys and you're at the highest rate. And there's also a huge administrative, let me stay in my lane and say, I don't know the full administrative difficulty of it, but I can only imagine and believe again, anecdotally, that over the years, I've seen a number of situations and times where we're having to wrestle with 3 rates on the same case in the same lawyer and figure out which rate are we at right now. And it has been on more than one occasion problematic. And it got to, let's tell on ourselves, I'll do that. It got to the point where about, I think it was 6 months or 8 months ago, I couldn't remember the 3 rates because they've been, I think, changed a few times since I've been here. And so,
I got Dorothy, you want
I just want to first say that I agree that we have to do this. And going back to what Art was saying, it's like, can we stand to not do it? I think that it is just, I'm always concerned about the impression that we are making or having on our, what I call our frontline people who are out there doing all the work. And about, as you know, we had a whole lot of that discussion in the budget committee meeting about, especially with this $5 increase, that it may feel like, oh, you're just throwing me some little bone or whatever. But I think that they would, when we said this before, that they will see it as it's something and we're working towards more, and we're always working towards more. And Art, I know we do have these discussions all the time, but I think that they will feel worse or more negatively impacted if we didn't have the discussions at all.
I'm saying we just need to do it.
Right. And I'm saying I agree with you. And I think that for me, that's always important that we publicly say that, so that when these minutes are, the minutes are reflecting that we do have that at the forefront of our decisions. And it's not us being like the legislators where they're just looking at the numbers and not thinking about the people who are impacted by that. The people being the attorneys, as well as the people that they're representing.
and it's not like you've got the easiest task, right? Like part of your role is to be doing justice. And that's a tough, we've been spending a couple thousand years trying to figure out what that means. And so, but I do think this, as for the 10+ million folks that inhabit this state, I think this would be a positive step. But I don't remember if I'm supposed to advocate for things or not. So,
well,
I can't remember.
I'll just say that the federal system operates on the same pattern of when it's declared non-capital, then you go back to the 150 rate instead of the 197. So it's not unprecedented. We're not doing something out of the box for doing that. The question then becomes, for another time, maybe if Alicia could run the numbers to see what happens if we say, if you're charged with first-degree murder, this is, whether it's capital or non-capital, then you get this amount of money. Maybe we could look at that to see.
We've
Meaning that even if it goes non-capital?
Yes.
yes.
Okay. All right.
And all of those variations don't have as much of an impact on the total cost.
So that's what this proposal is. It gets to a flat rate for all capital cases. And not only that, it also raises the rate to that level for juveniles facing life sentences, which I asked Elisa post-budget committee to cost out. You're going to hear more from Eric and Tucker about that later, but I think trying a kid for life in prison is kind of the moral equivalent of the death penalty, and we need the best lawyers on those cases. Brian asked me to talk about the risky scenario, but before I did that, I wanted to ask some of the commissioners who have maybe been around for a while what the rationale was for, because my understanding is years ago there was just one rate for capital, and then we went to the tiered rate. I do agree with what Rob said, because I do all these bills with Kati and Kristen and the staff in the office, and it's an administrative nightmare to read through every bill and make sure that it was billed at the proper rate, whatever it was at that point in time. So that but we can put up with that headache if it saves enough money. I'm wondering what the rationale was to have the staggered rates. Was it simply a cost saving measure, or was there some theory?
It was risk. I mean, yeah, when risk goes down, rates go down.
Okay. So Brian, we were talking over here and he wanted me to kind of address the risk. We're looking at a page 4 of Elisa's memo on how risky are these proposals over time. And, Elisa has kind of costed out 8 million, 10 million with 4E funds, 10 million without 4E funds, 9 million without, 9 million with, and when we would run out of money. And I kind of, I thank you, Darren. I don't know what they think of me over at the legislature. I think I made some headway with some of them, but don't know what to have run at a shortfall might change that. I don't know. So 9 million with 4E funds, from kind of a perspective of this is low risk, but we can still do a lot. The first year of the shortfall would be fiscal year 2028. 9 million without 4E funds. It was a relatively modest shortfall starting in fiscal year 2025. The riskiest scenario we have is 10 million without 4E funds. Shortfall starting in fiscal year 2024, 1.6 million that year, which is just like a 1-week delay in payment if we ran out of money. But then the next year it's 4.2 million and kind of balloons from there. I don't know, I guess I'm not much of a gambler when I look at how Elisa's broken out the 9.86. And is that right? 9.68 in proposed rate increases. We have to do something in district court, right? That's the biggest chunk. We have to pay those people a living wage. I feel, like I said, I feel strongly about the juvenile LWOP cases and that those people should be paid like capital lawyers. I just don't know where to trim this proposal that would get us down to this 9 million without 4E funds, right to I just don't know where to trim it in a way that makes sense. I suppose something that else you could do is build in some contingency for us should the 4E funds not start coming in by a certain date. And maybe that would make me a bit more comfortable. So that being said, I guess I've said my piece. I'd like your thoughts on that. And if anybody has some thoughts on, where do we cut? I'm open to that too. But again, I hear all day, every day from judges who can't find lawyers to do the work, from lawyers who are getting off the lists. It's bad out there. It's bad out there. So.
Can you guys hear me?
Yeah, go ahead.
Yeah, you can hear me okay?
Yes, sir.
Yes.
Yeah, it seems to me, if I understand the nomenclature that we're developing here, the recommendation that came out of the budget committee was the $10 million packet with the 4E funds. Is that right?
Yes, sir.
Okay. It seems to me, I'm sorry, that's a no-brainer that we ought to do that because we are in fact at a crisis. This is an underfunded system. The legislature doesn't give a good goddamn about our clients. It's the truth of the matter. It's a starving system. I mean, if God forbid there is a huge uptick in numbers of cases in the post-COVID era, what is going to happen? We're going to break. Already we're at a point where it's difficult to get lawyers in private practice to stay in the fight. The public defender offices are being overwhelmed in terms of case numbers, and things are going to start to break. So just, in terms of what we can do as a starved entity who's looking to do the best we can for indigent folks in big trouble, this seems to me to be a no-brainer that we do this. I mean, the longer term is what I am really sort of worried about. What happens when it's clear to the commission that public defender offices can't deliver constitutionally mandated service because there are too many cases. What happens when lawyers who do not, can't sustain themselves economically because the rates are too low, or just stop taking as many cases? What do we do then? I mean, do we sue the General Assembly a la Leandro? I'm watching that case. I don't know about you guys, but with very, very great interest to see what the dynamics are that play out there. Because, big picture is we're in crisis. And this seems to be an eminently reasonable, step to do what we can do. Now, I don't know when it's time for somebody to make a motion to adopt what the budget committee passed out to us. But when that time comes, I intend to vote for it.
I'm gonna let Brian.
I want to make sure that we're thinking clearly. Rob and Staples have been incredibly passionate and articulating what we've all been thinking. This system needs the money. Our PAC, our lawyers need the money. Our indigent defendants need the money. There's no question about that. And I'm a fan of deficit spending, but I think Mary misunderstood my risk question. What is the risk of going into deficit spending if the legislature gets pissed at us because we went into deficit spending? Because what happens if they say, you guys have failed your fiscal responsibility, we're going to shut you down? That's the risk I'm more concerned about. I have no problem spending money, and I think we can, and don't hear what I'm not saying. I am telling you, I agree with everything in the room. Everybody agrees the same. But there could be a risk that we push the envelope too far and it boomerangs and hurts this organization. So back to Darren's question, I am a risk taker. I'm in Cherokee. I go to Vegas every year. So I'm a risk taker. I'm not scared to bet, but are we willing to bet the future of this organization and its credibility with the legislature by going too far? Something to think about.
Mark.
I'll keep it short, if that's possible. I'm not a risk taker. I am a very fiscally conservative person, running multi-million-dollar budgets for a lot of years. But I think we owe it to our clients. When it really gets down to the brass tacks, we owe it to our clients. I mean, most of you know I'm a former warden. I don't make any apologies for that. But I will tell you, as a former warden, you gotta have good public defense. If you don't, you're not giving hope. And I think that's a critical thing about what we do, is provide some hope. Now, I know that sounds kind of mushy-feely, all that kind of stuff. But, huh?
Those wardens and their mushiness.
Yeah, there's wardens and their mushiness. But to run and I'm bringing it personal right now, to run an institution, if you don't have hope, you might as well give the keys to the inmates and walk out the door. And I think we're doing that some places in the country right now. And that's an editorial comment. But when we go back to it, we owe it to our clients to do the best we possibly can, to do the most we possibly can. And I'm not a risk taker. I mean, I hardly ever would ever say this in anything that I would look at from a budgetary standpoint. I'm the guy who says, whoa, wait, whoa, no. Folks, I am convinced that we've got to do this for a lot of reasons. And the bottom line is we've got to do it for our clients.
The risk I think that I'm concerned about, and could you expand on, Mary or Alicia, is what's the risk with us getting or not getting the 4E money?
If we don't get the 4E money, we would run into this shortfall scenario earlier. right?
Understand that, but
Right.
what's
Another-
the risk of whether
Of whether we
get
get it or not, your guess is as good as mine. It's honestly, I've heard about the 4E money since I started in August of 2020, and Judge Menefee's heard about it since long before then, and Elisa thinks it's going to happen.
No reason it shouldn't happen. There's never been any explanation for it taking this long. I mean, so, there's just,
It's something we get every year.
Elisa, that needs the, yeah, sorry.
the way it works is we claim our eligible spending every month. And we've actually been doing that for a year and a half. The commitment now is for them to pay us starting with our July claims, which are roughly 200, getting up towards $200,000 a month. And so we'll start getting those funds in. The way I did the scenario is those funds will accumulate faster than we'll spend them. And then by the time we get to 2023, there should be enough accumulated that we would move it into the PAC fund to cover the cost of the rate increases for the child welfare cases. So it's an ongoing thing. I mean, it's a federal program. The federal program could go away at some point, but it's the Title 4E program is what funds foster care in all the counties. So it's it's not a.
I just wanted to briefly respond to your concern. What are the repercussions to the legislature? I personally believe that the collateral consequences of acting aggressively and such that we be shut down are too huge and too significant for a legislature to take that step. It might be stupidity, ignorance, overly confident, but collateral consequences would be huge.
Right. So that's my question, because I was in the budget committee meeting and Chris was saying, before I got on the commission, she said, we ran a $15 million deficit at one point and we didn't get shut down then. So if that's the case, let's go for it.
Well, go ahead.
Not the
Sorry.
deficit. Not the deficit. Let's
Not the
go for
deficit, no.
Not that.
No, I just wanted to say that this morning, because, we have our 20th anniversary reception of the commission. I looked at the set of minutes for the very first commission meeting, and John Rubin was there, and Staples, I think you were there. And Tom Ross presided. I guess he was director of AOC at the time, and he basically said, look, folks, don't be fooled. You are here because the legislature expects you to save money. Here's the thing, though. I believe that the folks at the legislature understand the pay crisis and support attorneys being paid a fair wage. And I think as long as we can show that the money that we are spending is being spent in an intelligent fashion and not being wasted, I don't think they're going to throw stones at us for paying people a living wage. If there's other waste or something they perceive as waste, sure, but I think we can make the case that we're just doing what is necessary to maintain. So
Well,
I'll stop now.
In keeping with my belief of the glass being half full, I mean, if we have a $10 million package with the 4E funds, we're talking the first shortfall is going to be past the next budget year. If we get a budget increase similar to what we're hopefully going to get in the next week or so, we're going to cover that shortfall.
Oh.
Of $1.1 million, if that's the projection, right?
Well, that would be after the expansion funding. This is all.
That would be after
This is all-
yes, this is all including the expansion money and excluding, yeah, this is assuming we get all the money that we think we're getting and the 4E funds and set off debt relief.
Well,
And I think that the motion needs to be when you all vote, needs to be very carefully crafted to and be contingent on getting the 6.8 million and the set off debt relief. And then I think you all need to decide whether you want to make it contingent on the 4E funds starting to come in by a date certain or not.
well, my point is we're going to be at another budget year.
Yes, so if we're looking at a
If
shortfall,
we
we can.
got an increase, we would be covering our budget, our
Yes.
shortfall. at that
Yes, there's
point in
no,
time.
I could almost say 100% on that because
Okay, so if all of those contingency came into play, we wouldn't be facing a shortfall more than likely under that scenario if these numbers are correct and we were to get a new an increase in our budget in the 2020, what, 25 budget.
A relatively modest increase,
Right.
yes.
Okay.
Okay.
So that's what I wanted to say. So I think we've got to carefully craft, I don't recall there being a necessarily a motion out of the budget. I think we were going to let this be open for consideration. So, Brian, I'm going to look to you to ask because to craft a motion that takes into account these contingencies that would allow Mary to
I'm the wrong
utilize this.
person to ask.
So if
Because
we-
I was using the word deficit when I should have been using the word shortfall, so.
How about pulling,
Oh, sorry.
yeah, so we can hear you. Thank you. And if you want some time to craft that, I'm good with taking a little bit of a break because I think this is important enough for us to make sure that this is right.
That's fair.
So we're going to take a 10-minute break. Well, I agree. So we're going to take a 10-minute break and come back, and then hopefully Brian and Mary and Whitney can craft us a motion that we can all accept and live with, okay? I think it's that important.
People on Zoom, we're going to mute you, but not close the room.
All right, let's come back at 10 till 3. Okay. What's that?
That's only 7 minutes.
Okay, Mary. Full 10
Five.
minutes.
5 to.
Okay.
Now say it again, Darren.
All right, Staples, are you there? Okay, good. All right. If Staples got me, I'm assuming Jan and Stacy have us also. So one of the things we spoke about over the break is in crafting this motion, we have two components to this motion. One is the budget, the passage of the budget, and the other one is the receipt of the 4E funds. And so the question that comes up is, if we're going to pass the $10 million packet with the contingencies, should we have the contingencies with regards to, one, if the budget passes and we don't get the 4E money by a certain date, two, if the budget doesn't pass and we get the 4E money, or three, if we get both of them in a timely manner.
So Darren, here's what I suggest. Mary actually crafted this, so I'm taking credit for Mary's work. But why don't we propose the language and then we can decide whether we want to add the 4E language on the back end.
So I would open the floor for Mr. Cromwell from Mecklenburg County with a motion.
The great state of Mecklenburg?
The great state of Mecklenburg.
So I move to adopt the proposed $10 million packet for rate increase consistent with Elisa Walper's memo dated October 29th, 2021, contingent on the following: the adoption of a budget for the fiscal year 2021 biennium that appropriates an additional $5 million in recurring PAC funding and an annualized increase to IDS of $1.8 million from court fees.
All right. That's the motion on the floor. And since it didn't come from the budget committee, I need a second for us to enter debate. All right, we have a second. I will open it up for debate for any questions or concerns or comments that anyone wants to make. Is there? Yes, ma'am.
Clarify, that includes the safe harbor language too. When we say budget, it's safe harbor 5.8 and annualized new fees.
Mr. Cromwell, does that include the passage of the budget package as it is constituted at this point in time?
Yes, that's correct.
So he has an amendment to his motion. Do I have a second to his amendment? Sorry. All right. Is there any other further discussion? I just want to make sure everybody's clear with what we're voting on. We're going to give $10 million as long as the budget passes.
Correct. That's
Okay?
basically what
That does not talk about the 4E money. Okay. All right. I'm going to bring it to a vote then. All in favor of the motion that Mr. Cromwell from the great state of Mecklenburg made, say aye.
Aye.
All opposed? Okay. That's a significant thing that we've done. I don't mean to disparage the hiring of Mary Pollard, but until that moment, that's probably Mary Pollard being hired by, me being here when Mary Pollard got hired was one of the highest times, but this is kind of close in part. This is significant. Yeah, significant. So
I hope I think it's going to help. It is not ultimately going to solve the attorney shortage. It just isn't. There aren't enough folks out there doing the work. And there are big geographic areas where that's going to continue to be the case. But if this can help us get through until we can do some public defender expansion, it's a great thing. And the people doing the work deserve it. They deserve more, but they deserve everything we can do for them. So thank you, guys.
yeah, Mary will still get hate mail, and Dorothy Mitchell is the chair. Will get hate mail
at 5 o'clock.
Darren Jordan will not be the chair. All right, thank you. Well, thank you. That's great. All right. So we've done through the physical report. We have an IDS rule amendment that we need to talk about. Whitney, you want to pass the microphone over to Whitney?
If you'll give me just a moment to find the memo.
Did I catch you off guard?
Yes, I was just thinking about the momentous thing the commission had just voted on. The gist is that Mary, Susan Brooks, Sarah Olson, and I met last month to discuss whether or not IDS might want to pilot a contract expert program in a district or two. I will say that that is a nascent idea. There's a lot of anecdotal information out of the field that suggest it would be a great idea. We hear often that private assigned counsel and contract defenders do not utilize experts at the rate public defenders do, particularly investigators, because judges refuse to appoint experts. We wonder if some of it is because there are just a few too many hoops to jump through, et cetera. So it's an open question mark if there is a better way to connect private assigned counsel and contract defenders to experts, and particularly experts in those fields that they rely upon heavily anyway, such as investigators and mitigation specialists. There is nothing in the general statutes that would prohibit IDS from being the point of authorization or approval. We already do this in the context of capital cases and capital post-conviction cases, but we have left it in the hands of the trial judges for all non-capital criminal cases and non-criminal cases. I did some research, both Mary and I discussed it with John Rubin and others who were around when the original rules were written. Some of that is an artifact of kind of the political gestalt at the time. IDS represented a significant shift in the way things were done in the trial courts across North Carolina, a significant shift in some authority. And so non-capital criminal cases and non-criminal cases were generally left untouched. In other words, the status quo was maintained at that time, and it hasn't been revisited. But there is no reason why we couldn't revisit it. There may be reasons we shouldn't, but as Rule 1.10 currently is written, we could revisit it and not do anything about it. And so what we have done is propose an amendment to that rule that would at least allow us to further investigate, work with the committees, work with defenders in the field, and figure out what a pilot program would look like. And we would come back to the commission with the pilot program, already knowing that the rule was written in a way that would allow us to implement it should we decide to implement it. So really, it's kind of a prophylactic change to the rule, and that is what we are asking you to consider today.
So this is an enabling statute that will allow you to study it and bring it to the commission.
Yes, correct. It is an enabling statute that would allow us to study it, develop, bring it to the commission, and implement it if we determine that it is worthwhile and would improve things for our clients in the field.
We have, and that language is in your packet as to proposed change to that. Do I have a motion with regards to the adoption of the revision to Rule 1.10 of the IDS rules? All right. Is there a second to that?
Second.
All right. Is there any discussion, any questions? Is there a downside to us not doing this? There isn't.
Not yet.
Because we don't know what you're going to propose.
That's right.
Okay. All right. All right. Any other questions or discussion before we call it to a vote?
Thank you for proposing this, and we'll look forward to the ideas that come back to us or proposals that come back to us.
I think this is similar to when we did the immigration expert too.
It is similar,
Yeah.
and similar to the the high-level sex offense consults. It just really gives us a lot more opportunities. And I want to be clear because she's not here right now, and I don't think she's on Zoom, but this is really Sarah Olson, Forensic Resource Council. This is an idea that she brought to Mary and to Susan Brooks, and that they've really kind of started working on. I'm just, as general counsel, the kind of burden they have to jump over with the rules. So this is Sarah's brainchild.
So wherever you are, Sarah, thank you. All right, we're going to bring it to a vote if there's no further discussion with regards to this. All in favor of this motion, say aye.
Aye.
All opposed? All right, the ayes have it. Thank you for, that's just another innovative thought that's coming through and that helps lawyers. I think it's great. We're going to do the updates from the field. The North Carolina Prison Legal Services is Elizabeth Thomas here. If you'll come on up and we'll grab this mic right here, Elizabeth. I think she has a PowerPoint. Is that right? Okay. Elizabeth, I'll let you introduce yourself and get right into it.
Here's the move forward, back, and then this allows you to spotlight something.
Oh, wow.
See that?
That is really
How about that?
Hello, hello. Okay. Hi, I'm Beth Hopkins Thomas. I am so very grateful to be here today. Thank you so much for inviting me. Is this a good spot for the online? Okay. I wanted to first thank you all for the wonderful work that you do to ensure that everyone has quality representation throughout the state. First, I will speak today about the work, or first how I came to be at Prisoner Legal Services and a little bit of background about me. I will let you know some of the things that we've been doing for the last year at PLS, and I'll give a brief forecast of issues we're expecting to see in the next year. Do you mind if I? Thank you. So I came to PLS at the very end of August of last year. I got to fill some mighty big shoes, Miss Mary Pollard here, but I inherited an amazing organization. I am originally from Arizona by way of a Navajo reservation. I grew up in East Tennessee in the mountains of Appalachia. I came to North Carolina 2004 to go to UNC for undergrad. From there, I went to Charlotte and did Teach for America for 2 years in an underprivileged school in the Eastway neighborhood. Then I went to UNC Law. And it was while I was at UNC Law that I found my true passion, and that was criminal defense. And this became my passion because of a very personal experience, and that was when my older brother was arrested for opiate trafficking. We experienced the system through my brother and with my brother, through his trial level, through his appointed counsel, and then through the actual prison system. And so this always has helped me remember throughout my career what our work means to the individuals we represent, their families, and their communities. So after law school, I became a private defense attorney. I worked with a couple of firms doing both indigent and retained work. I practiced in all of the federal districts in North Carolina, as well as many of the state courthouses. I also taught at UNC Youth Justice Clinic for 3 years. And finally, I went to the district attorney's office in Durham in 2019, whenever Satana DeBerry was elected. I was on her management team and led the juvenile or youthful offenders team while there. And then that brought me to August of 2020, whenever I was elected to be the ED of PLS. I will say that one of my first experiences in post-conviction happened when I was a baby attorney, for lack of a better word. It was in my first year of practice, and I picked up a file at the firm that I had just joined, read through it, saw that it was an ineffective assistance of counsel claim against a young assistant public defender named Deontay Thomas. I litigated the case, won the case. Deontay now knows Padilla, but as some of you may know, that ended in a marriage a few years after that. Just a little bit of background. I think that you're all familiar with us, but we're a private nonprofit law firm governed by our board of directors. We currently have 19 attorneys, 8 paralegals, and 6 administrators or staff. I point out that we have a kind of large relative to our attorneys, staff, paralegals, because we operate still almost exclusively by letter. That's how we communicate with our clients. So we have to have a full team to keep the intake flowing. And they were amazing throughout COVID as they worked every single day and never got to go home or never got to work from home. Me and technology. Did I turn this off? Oh, that's the next one. That's good. What is meaningful access to the courts? So we provide prisoners with meaningful access to the courts as defined by Bounds v. Smith, which was a 1977 Supreme Court case written by Justice Thurgood Marshall, and it was out of North Carolina Central Prison, actually. The ruling held that we must give meaningful access to prisoners to the courts as required by the First and 14th Amendments, and that DOC, which is now DAC, must provide prisoners with legal assistance as part of that right to access to the courts. As a result, we were established the next year in 1978, so we are now 43 years old. 23 years older than y'all. So in our post-conviction team, this is also a very brief review. We identify errors and convictions. This can include ineffective assistance of counsel, illegal sentences based on things such as indictment errors, newly discovered evidence, prosecutorial misconduct, and innocence, as others as well. We have currently 14 post-conviction attorneys on the team. Here is our data for the last few years. We evaluate every request for post-conviction relief. We receive these requests either through direct correspondence from our clients from the prisons or oftentimes from judges assigning us to cases. And you will see some trends from this. You'll see a wonderful downward trend of prison population. We are now at the lowest population since 1995, but you can also follow how many files we've opened from all of those requests, as well as how many motions for appropriate relief we filed each year. And there's a note there, the lower prison admissions are largely due to a general downward trend, but also COVID-19. And here you can see with those corresponding years, a really cool way that we can measure the effectiveness of our work, and that's the days saved. So from those MARs and from consent agreements, you can see how many days per year that we've saved our clients. And you can see in 2021, even with our lower files opened, we've already saved a significant number of days. You multiply that by the cost per day per prisoner, and you see how much that we've saved our state and our clients. I would note, we always note this, that we can't capture in those numbers the days saved for clients in which we've had modified sentences from life sentences. And I would point out that we've had 4 of those so far this year: Michael Bullock, Randall Jenkins, Lamar Bass, and Clive Hunt have all been released from prison. Our other team is our civil team, and they address conditions of confinement. These can include failures to protect prisoners from other prisoners or from staff, adequate religious access, medical treatment. We very much look for cases in which that have far-reaching implications for as many of our clients as possible, and that can improve conditions. And then we provide self-help resources on how to properly file and pursue claims that we're unable to take directly, but then we also do direct representation for many clients. I would point out here that COVID has slammed us, as everyone here. It has created just a whole new level of need for our clients. We thankfully have a COVID relief attorney position from a grant that we received, but it's an all hands on deck situation still. We bring these claims, the civil claims, in federal court. We do 1983 civil rights claims. We also do what we call orders of investigation. We have standing orders with the Eastern District and the Western District, in which we are assigned by the judges to assist pro se clients on everything from discovery, review, and collection to doing negotiations and mediation to full-blown trial representation. We do tort claims in the Industrial Commission, and then we also file claims in state court. The most fun part. This is attorney Lindsay Bass with client Lamar Bass, no relation. She got him out of prison today, got a modified, this year, excuse me, got a modified life sentence to time served through her wonderful advocacy. We have many, many victories. I'll point out just a few more. We have attorney Kristen Todd has successfully argued a case in in the Eastern District of North Carolina, now in the Fourth Circuit, thank you. But she won in the Eastern District. Essentially, it was a habeas claim, but is essentially an insufficiency argument after exhausting it in the state courts. But we continue to fight that up to the Fourth Circuit. On the civil side, Corey Tischbein, one of our supervising attorneys, helped lead our team along with the ACLU to successfully settle prolonged hepatitis C litigation, which secured the rights for mandatory screening and proper treatment for clients with hepatitis C. That successful result has led to an award of attorney's fees, which will go to fund future impact litigation. And then one of our attorneys, Tatiana Miles, litigated and won a sexual assault case in the Industrial Commission and won a $25,000 award for her client. One of our directors, Lauren Miller, who's the director of training and complex litigation, has argued a brilliant equal protection case in front of the Court of Appeals for client Tiffany Marion. And she also has a significant innocence case, for client Utaris Reed that will be heard in oral arguments in front of our Supreme Court within the next few months. And our civil team is going to trial in the Eastern District on a 1983 excessive use of force case in 2 weeks. Some significant concerns that I have for 2022 and will be working on is trying to raise the pay of our attorneys to meet the pay of that of PDs statewide. Unfortunately, we are lagging behind in that, and that is a goal of mine. And I want to make sure that we are prepared to meet the needs of the influx of the COVID-19 backlog. all the trial level attorneys I know speak of all the trials that they're going to need to get through in the next year, next 2 years. And we need to be prepared to handle all of those as they come through post-conviction. And I would open it up for questions.
Questions?
I have a couple.
Sure.
First of all, thank you for what you do. And I heard that your predecessor was okay at her job. That's what I've heard through the grapevine. You said there were 4 people who were released from life sentences. How long had they served in custody before they got released? And just give me a ballpark.
The couple that I can think of offhand that I know better, they served at least 20 years on their sentences.
Right, so they served 20 years and they got out. Does your civil side then represent them in the inevitable wrongful conviction, wrongful imprisonment lawsuits?
Those cases weren't necessarily wrongful convictions or imprisonment. You know, they might have pled down to lower charges. And in the past, I know we've assisted outside attorneys with those lawsuits against the state. But one thing is that other private attorneys are very willing to take those cases, the innocence ones.
I'll bet.
Yeah.
And then the last question I have, I saw the number of MARs you do. Are most of those MARs based on equitable relief or technical violations of the law?
Well, the ones that get litigated are usually more technical. I would say the majority of them are technical violations, those indictment errors or errors in sentencing, using the wrong sentencing charts, those kind of things. But I think and encourage the team to be as creative as possible in looking at those larger equity arguments. And if you can look back, you can see on the Court of Appeals website, Tiffany Marion's arguments were really wonderful.
Thank you for what you do.
No, thank you so much.
Any other questions? All right, thank you for your, Kate.
Ask about the budget and how that works and how dependent are you on, I guess?
We're quite dependent on IDS. Our budget is made up a little bit over 80% of IDS grants right now. We're always looking for additional outside resources, but IDS is the main funder for us.
Any other questions? All right, thank you.
Thank you. Thank you so much.
Eric, come up and give us a report.
How's everybody doing? All right, I have a couple of preliminary things and then I'm going to go into my main spiel, all of which will be done in a very short period of time, I promise. Susan's saying 7 minutes. Thanks, Susan. So first of all, I wanted to introduce 2 of our newest folks, Terry Johnson. Terry, raise your hand. Terry is the assistant juvenile defender out in the western part of the state. You all might recall you supported and we received a position for this for Raise the Age. That's Terry. Terry was a contractor for over 10 years, has done private practice in Iredell and Alexander counties predominantly. So she still lives in Iredell to sort of be able to access folks out there. And she's done a great job. She started actually the week before the pandemic started. So I know it hasn't been easy. And that's why you're seeing her for the first time here today. Because usually part of the initiation is to make the new person show up to the IDS meeting, not just me. Next to her is Berja Hensley. Berja just joined a little over a month ago. Berja is another contractor of ours. Actually, was further west in Yancey and some in Madison County, but she's called Wake County home for a long time. She's taking the position of Kim Howes, who actually was the longest serving assistant juvenile defender, who's now serving in a consultant capacity, and I'll get to that in a second. But I just wanted to make sure I introduced them to you all today. Second, we have a bit of news. So there's a little bit of talk of grants and funding and all that. So You may recall that we had received a 2-year grant from the federal government to do Raise the Age training and technical support work. The money technically ran out September of 2020, but we increased the position at no cost through the spring of this year. And that was Austin Long, who was our project attorney. Well, in the meantime, we were trying to find funds to extend that work. We did receive a grant earlier this year for $117,000 for 2 years. But we just found out last night that we won an additional Office of Juvenile Justice and Delinquency Prevention grant that's $392,453. So we have now $500,009. No, is that right? Not 500,000, and I don't know. $509,000 to spend over the next 2 to 3 years. And Tuesday, we're talking to IOLTA about maybe getting some additional funding. So I wanted to, even though she's not here, she's actually taking the juvenile specialization exam today. But thank Austin. I'm sorry, what? I can laugh because I helped wrote it. Yeah. And I can also laugh because I can't grade it this year because, you know, either current or former staff are taking it. Anyway, thanks to Austin, we've got this money. I want to thank Elisa for her help putting the budget together and Mary for her help for support. Hopefully by the next commission meeting, we will have a plan on exactly what we're doing. But at the minimum, hopefully we're going to add personnel to keep addressing the ever-present changing topography of Raise the Age and the pandemic, which pretty much is changing every day, which leads me to my main point. So back in 2005, those of you who were around, you may recall that in Roper v. Simmons, the US Supreme Court eliminated the death penalty for anybody under the age of 18. And so at that point, the Capital Defender's Office quit appointing attorneys to those cases, and it was pretty much given to the local jurisdictions to appoint by lists or however it was being done. And then in 2012, the case of Miller v. Alabama came out, and this was a crucial case because this said that you can't have life without parole for juveniles under the age of 18 without a consideration of parole. And North Carolina wrote a whole new statute. And at that time, IDS actually came together and talked about whether or not there should be specialized attorneys for these cases. Kate, I know you were in that discussion. I don't know who else present was here, but if I don't mention you, I apologize in advance. But at that time, it was determined, you know, because the idea was possibly maybe the capital defender should appoint in those cases, but it was decided no, what we would do instead is sort of create an ad hoc resource group to try to support these attorneys in their work. So our office, Office of the Appellate Defender, Prisoner Legal Services, everybody sort of got together and we did the best we could for the next, you know, not quite decade or so, identifying these cases and providing whatever support we could to the attorneys representing these kids because the cases were getting increasingly complex. And of course, it meant life with or without parole. Then Raise the Age hit. So let's fast forward again now to December 1st, 2019, Raise the Age. And as you all hopefully know by now, every single individual under the age of 18 and now soon to be sort of-ish 10 through 17, we'll get into that, starts in juvenile court, regardless of what the charge is. So even these 16 and 17-year-olds who were charged in adult criminal court are now being charged in juvenile court. Well, we started seeing a lot of problems. First and foremost is that generally in a lot of these cases, there would be more than one attorney. So you would get an attorney appointed in juvenile court, and then a second attorney would be appointed once the juvenile is transferred. And that breeds a lot of issues, as you can imagine. There's no confidence. That second attorney has to start over again and try to explain what happened. If something went wrong with the first attorney, it was unclear what the second attorney could do about it. We also, by way of various cases, found out that the quality was quite low. We heard time and time again from either other attorneys or other stakeholders about what was going on, that the juvenile attorney wasn't sure what to do, that, our office, again, with the appellate defender, had created all kinds of motions and forms and constitutional arguments, and attorneys were either ignoring it or making very little effort in juvenile court to try to do anything they could to protect their client. And then again, it was shuttled off to the adult attorney. So as of this spring, after seeing all these problems, also considering the fact that we're having, a lack of attorneys, both doing high-level felonies and even starting to hit juvenile court, I started thinking about the idea that maybe our office should start acting like the capital defender and the appellate defender in appointing youth who are charged solely with first-degree murder. So let me be a little bit more specific. So we're talking about 13, 14, 15, 16, and 17. Those are the ages, because at 13, that's the earliest age you can be transferred in North Carolina. Right now, we're not really talking about anybody other than that group of people. 13, 14, and 15 are subject to probable cause and transfer. 16 and 17, they can be transferred either by indictment or by simple probable cause. But the idea is to create a similar roster with specific qualifications. Our office would be responsible for training them, for making sure they had technical support. And, locally, the clerk, the judge, whomever would reach out to us, and, we would know who in the area we could appoint. Kim Howes, who I just mentioned, is working for us about 20 hours a week, and I know has met with Rob and met with Glenn and gotten a lot of good information from them about how we might want to look to do this. And the reason, and I've also talked with my juvenile committee about this, so I know some folks have already heard about it. And the reason why I'm bringing it up today is because, of course, this will require IDS rule change to have us as the appointing authority, or however it's worded. And what I wanted just to do today is give you an idea of what we're trying to do, and make sure that you all support it. I didn't want to go too much further into this before I knew that we had the support of the commission. And if we do, the next steps are we'll start to put together proposed rules. We'll work very closely with Whitney to figure out how that would look. And best case scenario, maybe late summer, early fall 2022, we can start doing this. Maybe I'm being a little optimistic, but what we've seen in the field, unfortunately, is so bad that we feel like it's critical. If you'd asked me a few years ago, I would have said, heck no, I'm not doing this. But we feel like it's our obligation and duty to provide representation for these kids. Last thing I'll say is, I was mentioning the shifting sands of raise the age. This is also the case, unfortunately, with juvenile life sentences. Many of you are familiar with the Jones decision this summer. We have a new U.S. Supreme Court. The laws just go up and down. There's 3 cases from Glenn's office that are up for argument in the state Supreme Court next month. So it's very complicated. The law keeps changing, and we think we know of folks who are going to want to do this. So I don't know that there's an official request at this point, or a vote, or whatever, but I wanted to bring it to your all's attention. If you had any questions, to make sure to ask me, and hopefully we can move forward.
Yes, sir.
Eric, have you figured out what your desired outcomes are by doing this?
Well, hopefully they would either get, reduced sentences, or at least life with the opportunity of parole. That's the idea. Right now, that's only for felony murder cases for juveniles under the statutory scheme. Maybe. I haven't looked at outcome data. What we have looked at are the numbers of these cases. We've gotten a couple of different, we've looked at AOC, we've looked at DJJ. We're thinking, and somebody can correct me, we are thinking it's going to be annually somewhere between 50 and 60 or so cases. much less, than what Rob's got on his plate. But still significant enough that we think, we'd like to make this change.
I'd like to maybe suggest that your office crunch numbers with Alicia, find out what the, financial outlay is, and then bring a proposal to the commission. Is that fair?
I think that was the $10 million rate increase would incorporate a raised rate for people who use this contract. And I think, if I could just speak for a moment, I can see Dr. Thomas over there. When I was at Personal Legal Services, we saw a lot of really terrible
juvenile cases, where juveniles charged with murder, and because those were not potentially capital cases, they did not have the benefit of getting an appointment from Rob's roster, and it alarmed me, some of what I saw, and Beth can probably corroborate that. So I'm glad Eric is looking at this. He'll present a fully baked proposal, and we'll get the numbers for that. And I think Tucker has some thoughts on how this would work and the training.
All right, any other questions?
I would just say it's 10 years too late. I mean, this is so critical, and thank you, Eric, for bringing this forward and for creating a specialized roster and a rule change to allow for a specialized roster and appointment by your office. I think will just dramatically increase the quality of the representation for these extremely vulnerable clients. So thank you.
Thank you. Tucker, were you speaking on this issue or something separate?
Talk about
I'll let you go ahead and
training,
talk.
some trainings. Is that, you done? You got to be kidding.
Thank you.
Okay.
Nice transition.
That was quick. It's Eric.
Like that transition?
I do. I'm just going off script for a second. I mean, I know that there's been a lot of trouble with that Eric has spoken of, and I know that we saw it at PLS, but we do have a number of attorneys doing really good work out there for juvenile first-degree murder as well as other cases. I mean, really, really working hard. And Glenn's never going to see them, and PLS is never going to see them. I'm always compelled to put that out there, and I think Jeff would agree with that. So we all recognize that murder cases are very difficult, and children charged with murder, those cases are even more difficult. And so one of the things that Jeff and I recognized through the contract system is that, especially with the change in the law, there's a gap in the training. If you charge with capital murder, one of the benefits of that, of course, is you get Rob's office and you get consults. When you charge with non-capital murder, we don't have that institutional, built-in support for them. People ask us, we do consults all the time. But so one of the things we were thinking about is to have a three-pronged attack about this, this lack of support, I'll just say. And the first thing is this CLE that we're putting together with the Juvenile Defender's Office, with our office, and talking with PAC. And we're going to talk about, if you've never been in juvenile court before and you've got a juvenile now in Superior Court, what happened in juvenile court? I mean, I'm embarrassed. I mean, a number of times I said to Eric, when do you transfer juveniles? How old do they have to be? And he'll give me a great response. So you want to have a CLE. It's kind of a hybrid approach. You've never been in juvenile court. Here's what happens in juvenile court. And if you're going to be in juvenile court, here's a checklist of all the things you need to make sure that you do in juvenile court. And then maybe if you've never been in Superior Court, here's what's going to happen when you get the training and you go into Superior Court. Here's a checklist of things you need to do. We're going to talk about the juvenile brain. We're going to talk about, appropriate motions, preservation of errors, and actually go into trial. And then we want to have a web page on our website that's specific to this issue. The third thing we hope to do with this is to channel, provide a pipeline for people from doing juvenile first-degree murder to maybe doing capital first-degree murder. Because, we need to keep, Rob was talking about how low his list is. Well, if we can train people, a little bit earlier in their careers about taking on these cases, those will be the attorneys that we're depending on to do capital work later on. So that's what we're putting together.
Any comments or questions of Tucker? We thank you guys for your hard work, Tucker. So these are updates from the field, and Rob Sharp of the Capitol Defender's Office didn't give us an update because he was busy starting a taco stand. How's that going, Rob? Not too good. Okay. All right. You're welcome. So we are at the point where we want to recognize, is Antoine here? Okay, okay. Antoine Wigby, would you come on down with Professor Rubin? I'm sorry?
Phil Dixon.
Okay, Phil Dixon, I'm sorry. Okay. And I'm going to allow these two gentlemen to introduce Mr. Wigby and the purpose for our recognition of him today. Phil, you want to go ahead?
So welcome IDS commissioners, staff, and distinguished guests. My name's Phil Dixon. I'm the Defender Educator here, and I have the privilege and honor of awarding the Professor John Rubin Award for Extraordinary Contributions to IDS Training Programs, otherwise known as the Ruby. The commission in 2008 created this award in tribute to my boss and mentor and friend. Where's John? John Rubin. John, of course, has been a key partner to the IDS basically since the beginning. He's developed, planned, supervised, executed countless defender trainings, trainings for defenders and respondents, among his many other contributions to the field and profession. These programs have continued and become a standard part of indigent defense training in the state and are, in the estimation of many, the best legal education and skills training programs around. These programs depend almost exclusively on volunteers, and the Ruby is a way that we recognize those volunteers for their time, energy, and commitment. I can think of a few people, no one really more deserving of this recognition than this year's winner, Antoine Wigby. Antoine is a husband to his wife, Lama, and a father to his daughter, Lily. Antoine is a graduate of UNC Chapel Hill, as well as Campbell Law School. He's held licenses in state and federal courts since 2000, and since 2000 has just been a force of nature in Johnston County and surrounding areas, representing indigent defendants and juvenile clients, really at all levels from murder to the mundane. Antoine, you've been a fixture at our trainings since well before I was here and arrived in 2017, and he hasn't really slacked up any since then. He is a regular at the new misdemeanor program, the new felony defender program, the no small commitment of our week-long trial school, and our newest program as well, the higher level felony training. He selflessly gives his time and helps us provide the highest level of training to participants. And Antoine does it with grace, kindness, and humility. I'm grateful to have your help, as we all are. North Carolina is lucky to have you. And it's therefore my honor to present you the award, which I think is over here. Over here. Yeah. Right here. Congratulations, Antoine. From all of us.
I have to talk, okay. When I got the email from Whitney, I sent her email back saying, am I being pranked? Is this serious? I will say this to John Rubin, but for that defender trial school class, the first one that I went to, when I came back the next year, you asked me a question, I can't believe you're back. I said, you know what? When I was driving home from Chapel Hill to Johnson County, I said, why do I like this class so much? I will say that, but for that class, I don't know if I would still be doing what I'm doing. It is hard sometimes. My wife made a comment yesterday, my wife's right there. She does juvenile work and contractor work too. Sometimes you don't feel appreciated and you will get beat down, particularly in a place like Johnson County. But it recharges us to hear the new ideas, hearing what you have to say. Definitely hearing what you have to say, Beth, and everything that you guys do. So me going to those classes and helping out is really a product of what you guys have reinfused back into me, which is why I still do what I do. Thank you.
I think the Ruby wants to talk.
Oh, no, I don't, no. I just want to get a photo with Antoine.
Photo op. Awesome.
Go put your photos on. You can't really smile from that.
Why don't you pull them down?
Pull 'em down.
Pull them
Just- and
down.
don't
Just
breathe.
don't breathe hard.
Just don't breathe.
There you go. All right.
Are you serious?
A great award. I'm glad we're able to continue to present that. The next matter is in other business, the waivers of one-year fee application deadlines. I think there's one matter to take up. You want to address that? Okay, Chad.
I don't know how I'm going to follow that.
Here. You got it? Yep, you got it.
Good afternoon. What I'm going to be doing is just presenting a recommendation to the commission regarding the granting of extraordinary relief for an attorney whose fee applications were submitted past the one-year deadline. Oh, there we go. So just to situate us really briefly, the governing rule 1.9A, 1A is that fee applications for the attorneys have to be turned into IDS within 1 year of the disposition date. If they are not, a deadline waiver application can be submitted. I'll go ahead and remove this, sorry. If the attorney does not submit a timely fee application, they may apply to the director for a waiver of the deadline. But according to our rule, if more than 90 days has passed, the decision goes to the commission and IDS will make a recommendation. So the case we're looking at today, in your packets, I believe there was a memo as well as some redacted, a redacted spreadsheet of the fee apps that were actually presented. But the attorney's Harvey Rayner III, he went by Butch. We did receive 27 fee applications for him on behalf of Cumberland County Attorney Harvey Rayner. The applications were provided by attorney R. Andrew Porter on behalf of Mr. Rayner's widow, Elizabeth. Mr. Rayner did pass away on March 3rd, 2021. The applications were provided on May 17 of that year. Mr. Rayner was diagnosed with cancer in 2017. We have understanding that he was given a life expectancy of only a few months. He left employment with the Mitchell Law Group at that time, and on June 14, 2017, having survived those few months, he began the limited part-time work on the Cumberland County Juvenile Court Appointed List. This is, there's a link here to, excuse me, to his obituary, and our Cumberland County Chief Public Defender, Cindy Black, did volunteer to us that Mr. Rayner was a well-respected member of that legal community in Cumberland County. So the obituary is linked here. This is just a screenshot of that page. To the actual fee applications, there were 27 applications submitted. The date range was 2017 through 2019. There were 7 applications from 2017, 9 from 2018, and 11 from 2019. The total hours submitted are 235, and that's across a span of 3 years. So I just did the math, and that's an average of just under 80 hours of work per year. So he was definitely not working a full-time schedule, just doing a little bit of work, given the circumstances that he was in. The total of all the FIAPs submitted is $14,336.50. And in the packets, there is some redactions, but the fee applications are included there. And that includes disposition date, the prevailing rate at the time, what those fees would be if they were paid at 100%. And then also there are calculations presented where there can be a 10% or a 20% or 30% penalty, depending on what the commission finds, or they can be paid at 100% or 0%. So it's up to the commission, but all the numbers are in the packet. I didn't include them in this presentation. Just briefly, the facts are that these applications were all submitted past the 1-year deadline. They were also submitted past the 90-day window for director approval, which is why they're going to the commission. As far as the showing of cause, Mr. Rayner was diagnosed in 2017. He did only expect to live a few months. He did begin a limited part-time practice on the juvenile defender court appointed list. Our chief defender did let us know that he was a respected member while he was doing that practice, a respected member of the bar. The 27 cases that were submitted past the deadline do coincide in time with his onset, diagnosis, and treatment of what was a fatal illness. The last bullet point is just that there is no record in NCAS of any payments going to Mr. Rayner. So he did start this practice after the diagnosis. He never submitted the fee applications. They were all submitted posthumously. So our recommendation is in consideration of the showing of cause, a review of the documentation, and in communication with members of the Cumberland County Bar, as well as Mr. Rayner's widow. We do recommend that the commission approve extraordinary relief under Section 5 of the waiver policy. That would be 100% of the claimed fees, would total $14,336.50. Be glad to take any questions if anyone has any. More detailed information is in those packets.
All right. That comes as a recommendation from staff and the IDS director. Are there any questions? And if not, do I have a motion that we adopt and accept the recommendation as outlined on this last slide?
Second.
All right. Is there any discussion with regards to that? All right. All in favor, say aye.
Aye.
All opposed? All right, that passes. Thank you, Chad, for that work. And thank you for that presentation. I think that helps us kind of understand that. We are moving into we're moving into the quarterly misconduct report, which is in your packet. Unless someone needs to wants to be heard with regards to that, I don't know that there's any action item with regards to that. Whitney, do you want to say anything? Just need to stand up.
There was one attorney who has a stayed suspension or suspension that is about to enter a stay, or the stay is to be lifted. He is in Mecklenburg County. The behavior that led to his suspension was not related to his defense of indigent defendants, and he responded to the bar. So pursuant to guidance from the commission in the past, our recommendation would be that Mary contact the public defender in the district and let them know that an attorney who was on a suspension has had his stay lifted. I don't think I'm saying that correctly.
That or his stay has been raised or whatever. Yeah.
His stay has been raised. Ultimately, he is able to practice law again.
He's been reinstated.
Okay. Thank you, Darren.
Okay. So anybody have any questions about that? I think that's pretty straightforward. I don't think there's anything, unless you have seen something in your packet to go into an executive session over, and I don't think our council believes there's anything to talk about. Is that correct?
Thank you again, Darren. No, I believe that there may be issues we need to talk about in executive session in the near future, but that is better saved, not just for time today, but because of some things that are moving in the next 2 to 3 weeks. In other words, both Mary and I will have more substantive information that we can relay to you if you would give us a couple of weeks. And so the memos in your packet really give you what we know today.
Thank you. Is there any questions about any of that? All right, we have about an hour before the reception. I want to take just a moment. I know Rob Sharp is here and Glenn is. Glenn, do you want to say anything about your office? I know that I've talked to some folks. Seems like an exciting time for the appellate defender's office because you actually go to the Court of Appeals and not the Court of Affirms anymore. And you actually have a chance of winning, it seems like nowadays. So do you want to say anything formally to us? If you do, come on down and grab a mic. That would be great. We've been having some good criminal law stuff come out, believe it or not, out of the Court of Appeals, so, and the Supreme Court. So.
Thanks, Darren. I'm Glenn Girding. I'm the appellate defender. And yes, we have had some good success recently with our Court of Appeals, not so much at the Supreme Court. But the opinions came out today in some cases from the Supreme Court. Everybody can read those and take those for what they're worth. I believe the rate increases included the appellate roster. So thanks to the commission for that. I do believe it could help with recruiting, and I do think it could also help me with case management with regards to assigning some of the lower level cases to some of the better attorneys, and also maybe getting some attorneys to take more cases now that the rates might be a little higher. So I appreciate that. And our office is interviewing a candidate next week for an open position. We're hopeful that we can find somebody to replace Andy DeSimone, who has left our office to go work for the Federal Public Defender's Office in Raleigh. Otherwise, I don't have any other updates. Eric pointed out we do have arguments coming up in the Supreme Court with regards to juvenile life without parole. David Andrews and Kathy Vandenberg are arguing those cases in November, and should be some good arguments from them. Any questions?
Any questions of Glenn? That office is doing a great job. Thank you, Glenn.
Thank you.
Rob, do you want to come down and say anything else, or are you have you had your piece today?
Thank you.
All right. Thank you. Yeah, we have a question, Glenn.
Just really quick, no, you don't have to come back. Are those arguments, will those arguments be online on WebEx and YouTube like before?
Yes,
this Okay.
is supposed to be the first in-court argument at the Supreme Court since the pandemic started. We've had arguments at the Court of Appeals in the past month in person. Unless the Supreme Court changes at the last minute, they should be in person. But both courts are planning to have those broadcasts on YouTube. And the video and audio, at least from the Court of Appeals, has been pretty good, even watching that live on YouTube. So I would encourage people, you can just log in from your office. Obviously, you can have it played in the background. So I would encourage everybody to check those out.
All right, thank you, Glenn. I want to recognize also here from the public defenders is Dawn Baxton and also John Neiman. Do you guys want to come up and say something about what's going on? I don't know who's the president of that group now. Either one of you? Okay. Well, if the person's not here, y'all want to say something? Come on down here if you would, Dawn, and grab a mic. We appreciate you guys coming to the commission meeting. I think it's important that we stay connected with your offices, and I know you guys have a monthly meeting, and I know Mary sometimes joins that, so we appreciate it. So would you just let them know where you're from and who you are, and we'll.
Thank you. I am Dawn Baxton. I'm the Chief Public Defender in Durham County, and I appreciate you having us. And I would like to say, you mentioned those meetings, and those meetings have really helped us as public defenders navigate the craziness of COVID and make sure that we keep our offices strong. So I think we have relied on each other a lot. That's been helpful to help us get through the pandemic and still represent the clients well. So that's what's going on in my world.
Thank you.
I'm John Neiman. I'm the Chief Public Defender in Guilford County. What y'all have done today will hopefully be very helpful. We are at a crisis in private assigned counsel, getting people to take care of the overruns. We have 5 attorneys in Guilford County who are on the list for serious felonies. And it's just a real problem, and I think this will help, and I appreciate y'all's support.
Thank you, John. Susan, did you want to, I saw you raising your hand, if you want to.
Well, just take the thing. For those of you who don't remember, last year was the 50th anniversary of the public defender system in North Carolina. And because of COVID, we have a lot of materials left over from that, including this really nice foam board poster that whoever wants it can have, as well as many of the, well, actually we have 3 foam board posters and many not foam board posters. We will have t-shirts at the reception in big boxes. And if you ordered a t-shirt, I have your size, if you don't remember it. If you've gained the COVID-19, we have a lot of sizes, so you can probably pick. There are 2 that have name tags on them. They were special orders. You'll see those. But anybody that wants a t-shirt, the more you take, the fewer we will see on homeless people in Durham and Raleigh. So thank you.
Anybody else to address at this point?
I sent an email to staff and to the commission yesterday for those of you who may not have been included in the message or may not have had an opportunity to read it yet. I do want to note that our parent defender, Wendy Sotolongo, who usually is here, recently lost her mother. It was I think an unexpectedly quick illness. And Wendy is home with her family today. That's why she is not here, but you have I emailed you the obituary. You know how to contact Wendy. I'm sure she would appreciate any kind of show of sympathy or support you want to share with her.
Thank you.
Could you email her home address so we can send her a card?
I can do that. I will do that today.
Thank you.
All right. I do want to, I mentioned earlier that Channing Jones was not able to be here today, and I mentioned his email that he sent out, but I do want to just, for the record, let you know what he said, because I think it was really heartfelt. Channing had a death in his family, and that's why he couldn't be here. He said, "I deeply apologize. I won't be able to attend today's IDS meeting." And more importantly, he wanted to say, "It's been a pleasure serving on the IDS Commission. I truly have an admiration and appreciation for the great work that occurs daily throughout our state to ensure equal representation and profound respect for the men and women that serve our indigent population. It's my hope and prayer that many who endeavor to protect the rights of the less fortunate will be blessed and prosperous. Thanks especially to the commissioners who've been so kind with their time and knowledge. And again, I'm so appreciative. I'm confident IDS Commission is under great leadership and will continue to fulfill its mission." So I wanted to let you know that Channing gave those words of encouragement and thanks. The last thing I want to do is, as you know, this is my last meeting. I was sworn in as president of the North Carolina State Bar on October the 7th. And during my remarks, I made the comment that I am a product of my environment, and part of my environment has been being with this group for the last 7 years. There was an author by the name of C.J. Heck that said that we are all products of our environment. Every person we meet, every new experience or adventure, every book we read touches and changes us, making us the unique beings we are. And I think that's a product of everybody who's in this room. And I want to thank you guys for all of the service that you've provided to this commission over the course of the last my last 7 years. And I'm deeply appreciative that I was able to be here and be chair for the last 2 years. And I think that we are in very, very good hands with our new chair, Dorothy, and our new vice chair, Mr. Beeler. I had to give a written interview to the State Bar Journal. And so forgive me if you're going to read that. I would, you can read it if you want, but I'm going to tell you a little bit about, they asked me, how would you like your administration to be remembered when the history of the State Bar is finally written? And this has a lot to do with how I feel today about how my time on the commission has been. Ralph Waldo Emerson is credited with saying, to leave the world a bit better, whether by a healthy child, a garden patch, or a redeemed social condition, to know that even one life has breathed easier because you have lived, that is to have succeeded. And that's how I feel. So thank you all for with that. We will take a motion to adjourn, and I guess we have a little bit before we go. For those of you who don't know, the reception is going to be downstairs in the bottom floor, and just follow the signs to the cafeteria, I think is what they call it, or dining room. So thank you.
I should say, once you make it to the reception, which I hope everyone is staying for, if you get a chance, please thank Susan Perry for the amount of work and attention she has paid to it.
Yeah, she has.
And I just want to let everybody know, I don't know why I did it, but they had all this baklava at this restaurant I went to for lunch, and they just put it on, out on the counter, and I just bought 10 of them. So anybody's welcome to
Should we take it to the reception?
please take it to the reception. It's just there to be purchased.
Darren.
We're adjourned.
Well, I have
Darren, we're
this
adjourned, right?
Darren.
All right.
Darren. Learn these ropes.
Darren Jordan. We adjourned.
Yeah, we're adjourned.
Okay.
I'm sorry.
That's reassuring.
So,